you'd like to speak about, at least the first one, and when we start there, and that is, in your opinion, what factor or factors should be the most important that this commission consider when we make a decision about filling this vacancy?
I would identify 4 factors, Mr. Chief Justice, and let me appreciate the opportunity to come back and visit with the commission once again. Legal ability, collegiality, civility, and recognition and appreciation for the court's institutional role. We'll begin with legal ability, which may not require a lot of elaboration, but as a threshold matter, the justice who joins your court ought to have a threshold level of smarts, the ability to analyze what in some cases is a substantial amount of information, distill that information when crafting a legal decision, and in that decision, not only announce a result, but explain the result in a way that is, one hopes, reasonably brief, well-written, enjoyable to read, that is understandable to layman and lawyer alike. Collegiality, on a 5-member court, it's tremendously important that everyone get along well, that they enjoy their colleagues, that they respect their colleagues. These aren't just professional colleagues with whom you work, but you presumably spend time socially, you go to lunch. It's important that members of the court respect each other, appreciate their company. There may well be differences from time to time as decisions are being considered and with opinions written. One can try to transcend those differences and try to reach consensus, but to the extent that consensus isn't available, it's important to be able to disagree without being disagreeable. The kind of respect that one shows to each other is the kind that you hope to get back. Civility, frankly, just much of the same. Treating the lawyers who appear before the court as advocates in written product or during the oral arguments, show the same respect to the lawyers, the advocates, as you would want to be shown as an advocate yourself, and then you hope to show and receive from your colleagues.
So you use those 2 terms, collegiality and civility. I understand your collegiality has to do mainly with the way that the judges deal with each other, and civility the way they deal with other people outside each other.
That's correct. I certainly don't mean to suggest that you can therefore be uncivil to your colleagues. And finally, the recognition of the court's institutional role. Institutional reputations are precious, and they can be fleeting. They can be fragile. And once a reputation is lost, it can be awfully difficult to reclaim. And one of the reasons that this court enjoys the sterling reputation that it has, that it's attained and maintains, is because, in my view, the court does what courts ought to be doing, and that is it interprets the law as written, as it was intended by those who drafted the law, and doesn't instead superimpose views that may reflect the judge's personal predilections, but don't find textual or historical support in the document or documents that are being interpreted.
Your answer raises the question we talked about a little bit the other matters, and that is, what happens to the judge when you find that the law as written seems inconsistent with what you think that was intended by those writers? What do you do with this text or intent?
Well, to the extent that text differs from intent, it seems to me that text is what should trump. And I say that because in the separation of powers responsibilities that the court has, the job of the court is to interpret what the legislature has enacted. And if the legislature has enacted text that, I guess for purposes of rule of law considerations, citizens need to understand what rules shall govern their conduct so that they can govern themselves accordingly, so they can make decisions, so they can invest money, so that they can take certain actions, so that they're not in violation of the criminal law of fines or penalties that might be imposed by the legislature or by a regulatory agency. And the best way for citizens rather, to understand what the legislature may have meant is to read the text of the statute. Now, if the legislature concludes that the judicial interpretation of the literal text got it wrong, then the legislature, of course, is free to, and often does, come back and say, court, nice try, but you screwed up here. This is what we really meant. Institutionally, it seems to me, frankly, that there's a lot to be said for insisting on textual adherence so that the legislature can can make that correction if need be.
How do you believe we should be factoring in diversity, if we should at all, during our decision-making process here today?
Well, diversity is certainly important, to be sure. Gender diversity, racial diversity, different perspectives are valuable and ought to be part of the process. Allow me to suggest, however, that those aren't the only kinds of diversity that are relevant and ought to be considered. Other kinds of diversity, for example, perspectives that can be brought to the court from life experiences, diversity based on legal or professional experiences, those also, it seems to me, ought to be part of the mix. At the end of the day, this commission's charge, and what one hopes that the government will do, is select that candidate who is the most highly qualified based on any number of criteria. Diversity, to be sure, is an important one of those.
Let me make sure we have an understanding of your experiential, and we speak about diversity in that. When you finish your clerkship and went to work for Chicago law firm as an associate for there about 4 years, what kinds of work were you doing?
I was in the litigation department.
Okay.
I worked in some bankruptcy cases. I handled matters in the trial courts, the bankruptcy courts peripherally. Mostly they were on appeal to the district court or to the Seventh Circuit. Antitrust matters in litigation and antitrust counseling. And general commercial litigation, mostly federal court, usually invoking the court's diversity jurisdiction, commercial disputes, that kind of thing.
And then when you were with the Attorney General's office here as special counsel for about 6 years, what kinds of work were you doing there?
I started off doing antitrust enforcement, and I also had a different responsibility for what I would call the rules and regulations review. The Attorney General, as you know, is responsible for reviewing rules promulgated by the various agencies for form and legality. The Attorney General, both Generals Carter and Modisette, understood an important role, but didn't each night fly spec each rule that came across their desk. That responsibility was designated to me. After about 6 months, I was asked to get involved with, and did become involved with, some of the appellate matters within the office. They tended to be high-profile matters, though not exclusively. I handled some criminal cases, some civil cases. My first oral argument in your court, Mr. Chief Justice, was in '96, the year after I joined the Attorney General's office. It was a case involving some administrative law issues that were of some importance to the office and to the state institutionally, and I asked that I get involved with that. And then when General Modisette was elected, I guess in November of '96, and took office in January of '97, he asked that I stay on board because it was his view that he wanted Indiana to join what was then a relatively few number of states elsewhere that were investigating and beginning to file suit against the tobacco companies that lasted for several years, and I understand that some of that is still being litigated now based on what the Master Settlement Agreement means and how it's being interpreted in some states.
You were a plaintiff's lawyer there.
I was indeed.
Other than the Attorney General's experience, well, of course, then you went to Summer Bar and successor head.
Correct.
And your role has been pretty much the same in terms of the types of cases and clients you serve.
I'm a litigator. I have an active appellate practice, and that represents probably half of my litigation right now. I do plenty of trial court work, mostly federal, but not exclusively. Do some work in the state courts on both sides of the aisle, plaintiffs as well as defense-related work. Of course, in the state and federal appellate courts as well in my appellate practice.
Okay, and compensation, are you primarily on the clock with billable hours, or do you have any experience being a contingent fee lawyer?
The cases that I'm responsible for which I have origination, are almost exclusively, and I can't think of a contingent case that I brought to the firm. As we touched on during the prior session, one of my partners, Tom Barner, who has a well-deserved reputation statewide for his plaintiff's work, contingent fee plaintiff's work in toxic tort litigation in Mr. Homer's neck of the woods. I've had the privilege of getting to work with Tom in several kinds of matters in connection with those projects.
So the economics of that kind of practice are not foreign.
They're not.
Correct.
What matters most, the law and or the result of the law? In your opinion?
From the perspective of the court, getting the law right is the objective of the court. Judges may not like the particular result because were they in the legislature, they would have voted for something else. But it seems to me the judge's most solemn responsibility is to do his or her best to apply the law as those who wrote the law, whether it's a constitutional provision, a statutory provision, or a regulation or rule, have drafted it. And if we get it wrong, if the legislature or the agency concludes that court you messed up, they of course institutionally are perfectly capable and do and should correct the court's view of things. And I may be misquoting Justice Sullivan, but I've heard it attributed to him that he says, in substance, I sleep well at night knowing that if I get it wrong, there's always somebody behind me to fix it and get it right. And I think that's an appropriate approach to, at least when it comes to statutory construction.
Do you think the Supreme Court should encourage the General Assembly to redo laws that, in your opinion, maybe are not gaining the result that should be there?
I guess I don't feel strongly about that. I mean, the General Assembly has a job to do. It enacts policy as its elected, as its citizens believe the law ought to be. And the courts, when litigation is brought to the court's attention, the courts interpret those statutes. Both sides, I suspect, do the best they can to get the result that they think they're attaining. And if the courts mess up, the court can say, "This is, we reached this result for this reason." And if the legislature accepts that reason and says, "Okay, we're fine with that result," I'm not sure courts need to be prodding the legislature in that respect. My suspicion is that if the legislature thinks you got it wrong, they're not going to be shy about telling you so.
It just seems to me that the legislature needs pride every once in a while. I'm looking for somebody to do it.
She's lost faith in the rest of us here. Back to this issue of interpreting ambiguous laws. Can you give us an example of a case that you've been involved in where the law was ambiguous and the court ruled either way you thought was brilliant or wrong?
The most recent case that comes to mind that I've involved with was not so much a statutory question as a question of Fifth Amendment takings clause. My firm was involved for about 18 years, since I joined the firm, now 12 years, of active litigation on behalf of an outfit from just down I-65 in Seymour, Indiana, Roseacre Farm. Roseacre is one of the nation's largest egg producers, and was on the receiving end of USDA restriction forbidding Roseacre from selling in interstate commerce about 700 million of its healthy eggs for fear of salmonella transmission. Roseacre filed suit in the U.S. Court of Federal Claims, the specialized court that Congress has created to hear claims against the United States. It's waived its sovereign immunity and allowed itself to be sued in that court. And we brought a suit alleging what's known as a regulatory taking, a violation of the Fifth Amendment takings clause. I'll not bore you with 18 years of litigation, but sort of the end result of that was that at the end of the day, based on U.S. Supreme Court jurisprudence that, shall we say, is less than, it's not easily reconciled over 100 plus years of what regulatory takings means. We won twice in the trial court, we lost twice in the appellate court, and the Supreme Court of the United States at the end of the day decided not to grant certiorari. But what the Fifth Amendment takings clause means and how it gets applied or interpreted in a particular set of facts is difficult to discern. It's an area of the law in which I think both judges and litigants alike would plead for some clarity from the trial court.
Now that was a federal constitution.
It was.
Takings clause. We also have a state constitution and its takings clauses. As a judge in this court, you're called upon to adjudicate a claim that raises a claim under either of the constitutions. Do you feel the appropriate approach is to view those constitutions as living, breathing, organic documents that need to be understood in light of present-day culture, or do you believe that they should be understood in terms of the words or the intent of the frame?
the latter, Mr. Chief Justice. It's certainly important to understand how the values that were enshrined in the U.S. Constitution or the Indiana Constitution of 1851 have relevance today. Cherished liberties can be violated today with technological changes and so on in ways that were not envisioned a century and a half ago or 2 centuries ago. But that said, the values that the Constitution enshrined are those that were set at the time. Now, it's a living, breathing document only in this respect. The framers had the wisdom to recognize the importance that times do change, and that as circumstances change and new values come about that a majority of the citizens believe are deserving of constitutional protection, then we have the opportunity to amend the Constitution. It's been
the framers used the word like unreasonable certain seizure and other terms that allow you to apply it. Right.
That's exactly right.
Okay.
Just to follow up on that, as a living constitution or whatever, we have all this technology. And there's some recent cases where GPS is replaced in automobiles. And I think I just read yesterday something. The 7th Circuit, the 9th Circuit, which is a very liberal, basically allowed the placing of a GPS in somebody's car.
Well, please don't misunderstand my view. It's certainly the case that for example, use the Chief Justice's example of the Fourth Amendment, which guarantees against unreasonable search and seizures in connection with one's person's, houses, papers, or effects. There are technological means today, in 2012, by which those values can be violated that were never imagined by the framers in 1791 or our framers in 1851. And to the extent that there are technological changes today that can infringe on those rights, by all means, courts need to step in and aggressively protect the value. But it's the value that was enshrined in 1851 or in 1791 that counts, not a different value, a newly created value in 2012 that may not have textual or historical support.
Yes.
One of the papers you submitted, Mr. Slaughter, was a copy of your amicus brief on behalf of the Freedom Foundation.
Oh, yes.
But the court has not ruled on that case. By virtue of having submitted an amicus brief, your opinion is that disqualifying you participating in that case if you were a justice of this court?
In that case, absolutely.
Only proof no good deed goes unpunished.
Your law school graduation was
89.
89, okay. And when did you get your MBA? Before law school?
It was a joint program. Rather than earning them 2 separately, I combined them both in a 4-year program.
Bill?
Is there a case that you could talk about that you got great personal satisfaction from? That you thought you got a great result, or you felt like a client had been particularly well served? Could you talk about such a case?
I'd be happy to. Just for what it's worth, I get great satisfaction in what I do, and don't typically keep score, as it were, by, gee, wasn't that a particularly good brief, or wasn't this an especially nice result? That's nice, and I understand that's an important way of keeping track. And I'll be happy to talk about a recent case such as that, but that's not usually the criteria by which I measure professional success. A very recent case, probably the most recent case with which we've had success, is a case that was brought on behalf of a client, the Indiana Apartment Association, a trade association of some landlords who have members all over the state. And they brought suit in federal district court in Hammond, alleging the recent Hammond ordinance was in violation of the Dormant Commerce Clause because Hammond imposed rental registration fees differently based on the residence of the landlord, based on the residence of the owner. If you were a Hammond-based resident, you paid $20 per unit. If you were not a Hammond resident, whether across the state line or in nearby Maryland or elsewhere, you paid $80 per unit. It seemed to me it was, on its face, it was a clear violation of the Commerce Clause. The defendant, the city of Hammond, challenged it for a while. At the end of the day, after the district judge granted a preliminary injunction in our favor against Hammond's enforcement of the ordinance, Hammond Hammond eventually settled, the case has been resolved, declaratory judgment in favor of my client, a permanent injunction. The client's very happy. It's a good result, a notch in the gun, as it were. Yes, sir.
To follow up on the Chief Justice's previous questions with regard to practice in the last 6 months, as an example, how many instances have you taken depositions of parties?
We're in the process of depositions right now in a large case, toxic tort case.
And are you taking depositions, some depositions?
I'm trying to quantify how many depositions I've taken in the last 6 months. Probably no more than a handful, 3 or 4 or 5, I think, something like that.
And you indicated that you had not been involved in jury trial.
That's
So
correct.
most of your trial work has been bench trial.
That's right. I don't hold myself out as a trial lawyer. I'm a trial litigator. I do everything but try the case. I've seen a lot of jury trials. I've prepared colleagues for jury trials. I've read trial transcripts. But I'm not the guy who goes into court and tries the case. I have an extensive trial court practice, from pleadings to depositions to motion practice to post-judgment proceedings and, of course, appeals. But I'm not the guy who goes into court and tries the case.
I think I didn't understand that before. So have cases that you have worked on gone to trial, but you have not been the one who's actually tried?
That's correct. My in-court trial experience is injunction practice, motion practice, summary judgment motions, motions to dismiss.
Yes, Mark.
Who or what in your background would you cite a shaping influence on who you are? What has made you you?
Well, certainly my parents. Professionally, we spoke a little last time about the judge whom I worked, Judge Sharp, in the Northern District of Indiana. Had a tremendous influence on me, sort of a mentor in life and in law. Right now, my wife is my soulmate and my best friend, and she also has a tremendous influence over me.
You have children?
We don't have any children.
Summary judgment. You practice in the federal court, you practice in the state courts. Which summary judgment rule is that?
Am I playing for defendant? The Celotex trilogy. Well, the Celotex trilogy from 1986 in the federal courts, of course, is defendant friendly. It's easier to get summary judgment in federal court than in the federal courts. I guess the charter was 1994, I believe. The state summary judgment standard is a more difficult standard for a defendant typically to be able to satisfy.
The moving part.
The moving part, that's right. Typically the defendant, though that's not necessarily the case. If I were writing on a clean slate, I'm not sure I would adopt the Jarvis standard, but that's been the law of this state for 18 years, and I'm not looking to undo long settled case law there.
Technology. You told us when we last interviewed you a little bit about in fact, you may have undersold your technology background. I'd like to explore that a little further. What kind of technology do you use in your practice right now?
Word processing, email, Westlaw, the internet to review cases and do Google type searches. I have, in the other room, the phone that I'm able to keep track of those things in a mobile way.
You need to check that case that somebody cites to you. Do you go online and use Westlaw or Lexis, or you can go to pull down a book and look at it?
I almost never use the books anymore. I may well print out a case from Westlaw or online. I find it more difficult to read on the screen than to have something in front of me to be able to read and mark up and so on. But I, for example, keep track of current cases through the court's own website, through the Indiana Law Blog, through the Indiana Lawyer Online service, and of course, to the extent that something's not available on one of those free websites, make use of Westlaw.
And you file in the federal court using Pacer, and you're very comfortable with that?
I I have those passwords. My assistant actually makes sure, and at least in the Seventh Circuit, I'm perhaps telling you something you already know, but there is a PDF that's scanned, there's a PDF that is printed. And I don't know how to print to PDF, but the Seventh Circuit requires that briefs in that court be printed to PDF. So when it comes to those filings, I ask for assistance on that.
Excel, another program, you use those?
I'm sorry?
Excel spreadsheet, another application, you use those?
I can use Excel. I'm not somebody who's skilled in generating the cells that create the formulas that.
Okay.
I was just gonna ask about JTAG. Are you familiar with that?
I am. I do use it. It doesn't exist, for example, in Marion County. It doesn't exist in a lot of the state courts in which I currently practice, to the extent that I have a case outside of Marion County that's on the Odyssey service, or I think DocsPop, I think is the other one. I make use of those, but it's a relatively infrequent part of what I do.
Do you think that JTAG and Odyssey should be pursued throughout the state and every county?
Absolutely. Absolutely. I think the sooner, the better, the faster we can extend the technology and the automation to link all of the courts in the state, I think the better.
Well, let me ask the second question that we provided to you, and that is, in what area do you feel the Indiana Supreme Court could most benefit from improvement?
I think I would, the area of the court's involvement that I'm most familiar with, this deciding cases part, I don't have any suggestions for improvement. It wouldn't change a thing. What occurs to me, and I'll refer to those who know better about these things than I, but what occurs to me as an outsider is, this is a little bit from my MBA training, the court's administrative responsibilities. You have, of course, supervisory and oversight responsibilities for the state judiciary, for the practice of law in the state of Indiana, and you have, I understand, hundreds of employees who make up the various boards and commissions and agencies that are responsible for helping you carry out those duties. Also, as I understand things, each of the executive directors or counterpart managers who are responsible for those different agencies have direct reporting authority to the court. And one suggestion that occurs to me is to consider that it seems to me that administrative arrangement might lend itself to having one or more professional managers overseeing that entire administrative process. To the extent that the court views itself as a board of directors, boards, typically in the corporate setting, of course, are responsible for deliberating and devising policy and leave it to the managers, the professional people, to implement that policy on a day-to-day basis. And maybe the court's perfectly contented with the current arrangement, in which case, if it ain't broke, don't fix it. On the other hand, if there were one area for an opportunity to have management helping the court implement the day-to-day policy, it seems to me that might be one way of approaching that issue.
Very tactfully presented. Thank you for that. Any other questions anyone might have? Mr. Slaughter, thank you for coming.
Thank you for your time. I appreciate it.